You know, we've all heard those stories about nightmare HOAs. But what happens when you have a mountain of evidence against yours and you still lose? Well, this is one of those stories. It's about a homeowner, a bunch of weeds, and a single sentence hidden in the fine print that completely flipped the script. And that really is the question here, isn't it? Can over 300 photos of hard evidence just not matter? Is it possible for all that documented proof to mean absolutely nothing in the end? Let's get into it.
All right, so let's meet our homeowner, Debra Morin. She's a resident in an Arizona community called Solera Chandler. Back in March of 2020, she filed a formal complaint against her HOA, and that one complaint kicked off a legal fight that would go on for almost a full year. Now, her argument was pretty simple, and honestly, it sounds totally reasonable. She basically said, hey, the HOA should have to keep the community areas looking just as good as it forces us homeowners to keep our own yards. You know, what's fair is fair, right?
Okay, so this is where things get tricky. The community's own rules actually set two very different standards. For homeowners, the language is super strict. Your property has to be weed-free 365 days a year. No wiggle room. But the HOA's duty? It was way more vague. Just keep the common areas in good condition. That tiny little difference in phrasing? Yeah, that's what this entire case is going to hinge on.
So Ms. Morin knew words weren't going to be enough. She needed proof, lots of proof. So she got to work building a literal mountain of evidence, documenting every single thing she felt was a failure by the HOA.
And when I say a lot of proof, I'm not kidding. She put together this huge file with more than 310 photographs. Every single picture was a piece of her story, showing the problem she was seeing day in and day out. This wasn't just some angry email. This was a carefully constructed case.
And look, this wasn't just about some weeds popping up here and there. No, she documented everything. We're talking broken curbs, exposed wiring from the landscaping, storm drains that were totally blocked, old tree stumps just left there, the whole shebang. She was painting a really detailed picture of what she saw as complete neglect.
So you've got this mountain of photos. How in the world does the HOA defend against that? Well, it turns out their strategy wasn't really about defending the facts at all. It was much, much cleverer than that. This is where their legal strategy gets kind of genius, actually. The HOA didn't argue about the weeds. They never said, nope, those pictures are fake. They just didn't engage with the evidence. Instead, they completely changed the conversation. They argued that this case wasn't about the weeds. It was about who gets to decide what good condition actually means. And like in so many of these fights, the answer wasn't in the photos. Nope. It was buried deep in the fine print of the community's CC&Rs. That's the official legal rulebook for the whole neighborhood. And this right here, this is the moment everything changes. The entire case, all 310 photos, all the arguments, it all comes down to one single clause. Just a handful of words in a very long, very dense legal document. And there it is. The board shall be the sole judge. Just let that sink in for a second. The sole judge. What that's basically saying is that when it comes to the upkeep of the common areas, the only opinion that legally matters is the board's. So what that means in plain English is that the board has the final say, period. It didn't matter what Ms. Morin thought good condition meant. It didn't matter what her 310 photos showed. As long as the board itself decided the maintenance was good enough, then legally it was good enough. And as if that wasn't enough, there was another clause that basically put a lock on it. Not only was the board the sole judge of the maintenance, it also had the exclusive right to interpret its own rules. And their interpretation was final, conclusive, and binding. It's like a legal fortress. Okay, so the HOA has this legal superpower, this sole judge clause. How did it all play out in court? Let's take a look at the final ruling. So it all kicked off in March 2020. By August, the first decision comes down and it's in favor of the HOA. Ms. Morin appeals and she gets a rehearing in December. But it didn't change a thing. By January 2021, the final decision came in, upheld the original ruling, and the case was dismissed for good. So you can see the whole conflict laid out right here. On one side, you have Ms. Morin saying, hey, the rules should be the same for everyone. On the other, the HOA is just pointing to the rulebook and saying, nope. We're the sole judge. And in the end, the court agreed with the HOA. They concluded that because of that one clause, she just couldn't prove they'd actually broken any rules.
And this is the part that is just so wild. The court never said the weeds weren't there. It never ruled that the photos were wrong. It simply said that based on the contract she agreed to when she bought her home, she had given away her right to legally challenge the board's judgment. The entire case was won not on evidence, but on pure contractual authority.
So this whole story really makes you think, doesn't it? It's a huge reminder that the fine print, it's not just fine print. Sometimes it's the whole ballgame. Debra Mornin's entire year-long battle was lost because of one single sentence she probably never even knew was there. Which kind of makes you wonder, huh? What's hiding in your community's rulebook?